We don't want people to look away, but also your well-being should come first. If you need to step away at any point, please do so. If you're in crisis, please call the National Sexual Assault Hotline, 1-800-656-HOPE. That's 1-800-656-4673. They are available 24/7. As we begin, we are opening with a powerful message from a survivor who could not be with us today, Lara Bloom McGee.
Sisters, today we stand together, not as broken pieces, but as a fierce, unshakable whole. Each of us carries a story no one chose, but together we choose how to respond to those stories that shape the world. We are choosing to be light. As you gather for this 24-hour filibuster, remember this is more than a protest. It's a spotlight on truth, a demand for accountability, an insistence that our voices be heard until change follows. Your presence matters. Your words matter. Your endurance matters. When I first walked into the reading room last week with my survivor sisters, Danny and Liz, I felt the weight of the action, of promises, not platitudes, but real work being done. Rows of 3,437 bound volumes stood as proof. Disclosure made physical, a record the world cannot easily ignore. That sight steadied me, and that sight fuels us. If the truth is hidden, we will amplify it. If names are redacted, we will demand restoration. If accountability is delayed, we will persist. We didn't choose our abuse, but we choose how we respond. We choose to keep this fire burning until every single person responsible is held accountable. We choose solidarity over silence, action over resignation. Lean on one another and use your voice. Rest when you must, then rise again. This filibuster is another chapter in a fight we will win, because when we stand together, each voice lifting the next until justice is not a hope, but a reality. Keep the light, keep the fight for ourselves, for those who cannot, and for the truth. I love you.
Remarkable words from Lara Bloom McGee that get to the heart of what we are doing here today for the next 24 hours. This is accountability, and we are not going to let people look away. We are honored to be joined now by Danny Bensky, Charlene Rochard, Jenna Lisa Jones, Marika Chartouni, and Jess Michaels, all survivors. Danny, we'll begin with you.
Am I good to go? Okay. All right. Hello, everybody. I am Danny Bensky. I am an Epstein survivor from 2004 and 2005. Survivors have fought for the release of all of the files to get closer to truth, transparency, and justice. Our goal has never been to expose victims' most personal and sensitive information or to be political pawns. There are three major problems that we have seen: the redactions that protect perpetrators and release all of our information. 2, we still haven't seen the full release of the files. 3, our government, and specifically the DOJ, has not done its job to pursue investigative leads. Yet, again and again, survivors are always asked to do more. We're always asked, name the names. It's something that we hear over and over and over again. And guess what we have? We actually have it to Congress, to the FBI, in spaces behind closed doors many, many times, but clearly that doesn't seem to do it. So they're all in the files. So this is a great opportunity. We're really grateful to the reading room to give us this opportunity for radical transparency, where we do actually get to read the files. So I'd like to start with the first page of our whistleblower, somebody who is so heroic and brave, stepping forward before anybody felt safe and felt like they could. Maria Farmer has led the way, along with her sister Virginia Giuffre. on a lot of this. And so I'd like to start with her 1996 report. Now, I want to mention this is only the first page of her report because we still haven't seen the other half of the files be released. So here it is. This is subject's name and alliance, Jeffrey Epstein. Character of case, child pornography. Complainant stated that she is a professional artist and took pictures of her sisters, 12 and 16 years old, for her own personal artwork. Epstein stole the photos and the negatives and is believed to have sold the pictures to potential buyers. Epstein at one time requested, redacted, to take photos of young girls at swimming pools. Epstein is now threatening, redacted, that if she tells anyone about the photos, he will burn her house down. That is her first report. Epstein's power was so vast and profound that he also was able to get members of the medical community to violate their oath and treat victims. At Epstein's direction, even hospitals and doctors were complicit. So I'm going to trade this out and read a bit of that. Put this here. Is that okay, so this is to Jeffrey's email from redacted. Or no is the first email. Second email, did Eva call you? Do you have off from school Friday for holidays? Eva will organize pussy doctor. Jeffrey, I told you I didn't give my application yet till I will accepted by the International Volunteer Service Department. This is Jeffrey, an application for volunteer that Sue was supposed to help you with. Okay, great. Thank you. What an application means. Where can I get it? This is Jeffrey again. Not yet. You must first go to the gyno. I just hung up on Eva. She's going to call you. Did you fill out an application yet? Then responds, do you mind if I fuck someone with a condom? That is there. Eva gave me 2 numbers, and I call. First number, they said closest date could be only next week, and then I called to the second, and they have free space for tomorrow afternoon, so I make the appointment with them. They said first visit to the doctor without the insurance will be $600 in cash. Isn't that too expensive? He responds, find out how much and get Bella to pay. I pay. Hi, Jeffrey. Eva gave me the number of the doctor. I will call and make appointment, but what should I do if they ask how I will pay? Let's switch this out. Sorry. Okay, fine. This is actually from redacted to JE jail is the name of this. Maybe not, but all doctors you pay directly keep you well informed about my treatments anyway. With this one, I don't feel comfortable in this situation. She believes I pay for myself with money you have given me. Jeffrey responds, of course not. It simply avoids gift tax. I can pay doctors directly. I would never read your emails or invade your privacy. Do you believe she thinks you pay for it yourself? She responds, is that a joke? If I am going to feel comfortable taking advice from someone, it's not a person on your payroll and wouldn't take that confidentiality away from what I tell her and give you the right to know. She said, Jeffrey says, I can pay it directly. And one final one here. Thank you. To redacted from Jeffrey. I'm going to sleep. Magnian or Kruger, they call to confirm they have done their best. They are the 2 best doctors in their field. If you wanted confidentiality, you could have just said so. Since I was the one that had called them, they report back I had taken the time to call, and they take the time to make sure that I am happy. You have gone to many doctors, gynos that I didn't call. I didn't call blank. I didn't call your cellulite treatment place. You want VIP treatment. Your hair cutter calls. I repeat, I have never invaded your privacy and spend most time helping you grow. Tell me how you could have, tell me how you've helped me grow. Read how your interactions are what you don't want me to do. So there are investigative leads, and we need to follow them. Thank you. Very good.
Hi, my name is Charlene Rochard, and I appreciate the opportunity to speak during the 24 hours Epstein Files Filibuster live stream here in the Trump reading room. Keeping this story alive matters, and I'm grateful to contribute my voice. I want to take a moment to share why it is so important for me to be here today. I stand before you not only as a survivor of Jeffrey Epstein's trafficking, but as a legislative advocate, someone who has turned her lived experience into a force for policy change and protection. I'm grateful to use my voice, my expertise, and my lived experience as a trafficked model to help shape the reforms that are long overdue. Every time I have the chance to speak, I'm working to strengthen laws, oversight systems, and protections I never had when I was a young model trying to build a career. For years, survivors like me were treated as collateral in the Epstein case, silenced, dismissed, and excluded from the very processes that shaped our lives. Standing here today represents a meaningful shift. This reading room transforms documents into something human again. These files are often discussed as headlines, politics, or internet discourse. But behind every page is a real person, a real life, and experiences that do not disappear when we finish reading. For the public, the files are just information. For us, these are memories, bodies, fear, confusion, and grief. I am here with firsthand knowledge of how this trafficking network operated, and with a voice that contributes to what happens next. My presence signals that no survivors are no longer being kept outside the conversation, but are finally being included in the work of accountability and reform. I'm here because these files contain pieces of stories like mine, the story of a young model who was trafficked through Epstein's network without understanding the danger she was in. My presence is a reminder that these pages are not abstract. They are lived lives, real trauma, real institutional failures. They also contain investigative leads, patterns, connections, and unanswered questions that deserve serious attention and continued examination. As I review these files, I ask that you too also examine institutional breakdown leads, grooming tactic leads, enablers leads, financial leads, and the blind spots that must be addressed if we want meaningful reform and a safer world for my children, your children, and future generations. This is the core of my legislative advocacy, and my role today is part of a broader effort to ensure that what happened to me and to so many others is never allowed to happen again. Epstein was able to operate his trafficking network with consistent access to large amounts of cash and financial professionals who helped facilitate those transactions. These files include bank statements, withdrawal requests, and communications tied to Jeffrey Epstein's financial network. More than $1.5 billion in suspicious transactions connected to Epstein network were reportedly flagged across multiple major financial institutions. Here are just a few. investigative leads. Document EFT A013524552. As discussed with Stu, Mr. Epstein or Mr. Indyke are currently able to make a large withdrawal of $100K or more from the personal account before the branch officially closes on February 1st. The bank will need advance notice on this transaction. Document EFT A013461244. This is called a large withdrawal. The branch says the cash will be ready for pickup Wednesday afternoon. Is the delivery of $100 bills are expected to arrive early morning? The lawyer replies, let's do Wednesday, as we prefer $100 bills. Document EFT A02298649. Jeffrey does need $6,000 in his black bag. Redacted. Says he has no money, equals in there. Rich brought money and you could get it from him. We cannot change what happened, but we can decide whether we are willing to examine the systems that allowed it to continue in plain sight. Thank you.
Hi, my name is Eliza Jones, and I am a survivor of Jeffrey Epstein's. What you are about to hear for this 24 hours is uncomfortable, disturbing, impossible to ignore. The Epstein files are not just documents. They are fragments of a hidden world where influence shielded behavior, silence protected reputations, and power moved behind closed doors. Every page raises the same question. How many people knew and how many chose to look away? I'm going to read EFTA 00009117. A little context, this is Alex Acosta being depositioned. Question, and at the time, blank saw the NPA, he sent a message to blank about his view of the NPA, and you didn't see it, but I just wanted to name some problems that he identified with the deposition and get your reaction. Question, to it. So first, he says, I'm not thrilled about the agreement, but he acknowledges that out of his hands. He says in terms of the charging and sentencing he's getting, Epstein is getting a much better deal than the average defendant, with the exception of the defendants who have done physical harm to their victims or abused very young children. We haven't seen more egregious conduct, but of its serial nature. The area we need to be most careful about relates to the victims. The U.S. should seek to ensure that the plea, which is not giving him serious jail time, provides the best means possible to address the harm he caused to the victims. That generally means restitution and/or therapy. While the agreement provides facility for the victims, the relevant terms still seem pretty advantageous for the defendant and not at all helpful to the victims. They get an attorney who will be paid by the defendant, which involves at least some conflict of interest, or they could hire their own attorneys on a contingent basis, and they get waivers from the defendant when his plea would facilitate their civil cases in any event. Then they still have to sue him to get anything. Most times with wealthy defendants, we make them agree to a restitution fund, and then still provide that the victims can sue the defendant independently if they choose. We always make them clearly admit their guilt. No NOLO pleas. This is incredibly important to the victims. I would have taken the guy to trial unless the victims were clearly against it. And I don't think most of them are here. He says to blank, who by this time is working for, he answers. Question, blank, redacted, complete question, redacted. Answer, right. So that's the context in which he's addressing it. Blank specifies that blank wouldn't and shouldn't address this agreement. So that's that. The issue that was then before blank put there by Ken Starr was the whether this 22.55 scheme or scenario set out in the NPA was appropriate. It appears that she then sent that back to you. Answers, right. Question, but as far as blank's commentary of the NPA, if you had been aware of this perspective at the time you were, that you and your people were fashioning the NPA, would that have been helpful to you in deciding out on how to proceed? Answers, so may I. Question, yes. Answer, okay. I assume you read the whole thing, but let me just take it. Question, I have. Answer, and so for a few comments, first let me say he was part of the September hearing. He answers. And to my recollection, these perspectives, at least the outlines of the agreement, were disclosed at the meeting, and I don't recall the type of communication at the time. Okay. I also recall there was a lot of back and forth around this restitution fund, and our perspective was that the restitution fund puts the victims at a disadvantage. He answers. And because, let me try to recreate. I don't recall the details, but I recall that there was a perspective that the restitution fund, cuts him off, and then answers, put the victims as a disadvantage. And there is some reference to blank. Was it an Alaska case? It's called the blank case. Mr. Blank Blank, the witness blank, Miss Blank, 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 blank. Yeah. And so the extent that there were better ways of crafting this, that certainly would have been highly relevant because, to my recollection, we were not wed to any particular way of crafting it. The intent of the 22.55 was to come as close as possible to putting the victims in the position that they would have been tried and convicted federally. And so to answer your question is yes. Is yes, that would have been helpful? Okay, as soon as you set the addressing, the 22.55, you consulted with blank. Do you recall that? I recall consultations. I don't recall it specifically with blank, but did you know her? Yes. Okay, do you recall the nature of your interaction with her? I don't. I know from contemporary review of the record that there is an email from her. It's 41A. Yes, 41A. And what I want to ask is simply 41A is an email in which you note to blank who was blank, right? One of the deputies, she oversaw CEOs. She blanked mentions to you that blank was looking at this, which is the 22.55. So in context, this was them talking about his sweetheart deal. They had hidden emails, secret meetings to discuss his sweetheart deal. In the beginning of us, when I read, was Jeffrey being upset that he got the best deal ever in history. So I want that to be a reminder. That's not how our government is supposed to work. And keep reading.
Thank you, everyone, for having me here today. My name is Marika Shartuni, and I'm an Epstein survivor. I'd like to read one email for a Jane Doe from Jeffrey Epstein to Redacted. The date is 4/16/2009. Give me a number or email, I'll ask. I have no control anymore. Demon. If so, sent her to Palm Beach to learn to drive. Can't do Israel anymore. Okay, that is weird. I hope we don't start again with Israel. Dumont. Never heard from her. Do you want me to call? If so, give me a number. Did you hear from M? Getting a little concerned. Not a word for a couple of days. But she says plans are in action. Last night's opera went really well. And a lot of people are interested at the party after W.H. Liberest. That would be me. Real mafiosa country here. As in, they own the opera, basically. I'd also like to read some sections from the 1953 Trust. Thank you for being patient with me. Bequest. I make the following general bequest. Karina Shuliak. If she survives me, $50 million. To Darren Keith Endike. If he survives me, $50 million. Richard David Kahn. If he survives me, $25 million. To Redacted, if she survives me, the amount of $10 million. To Redacted, if she survives me, the amount of $10 million. In addition, if she survives me, my trustees are directed to pay an additional $5 million to be distributed as per redacted instructions. To Redacted, if she survives me, the amount of $10 million. To Redacted, if she survives me, the amount of $5 million. To Redacted, the amount of $10 million. To Redacted, if she survives me, the amount of $10 million. To Redacted, if she survives me, the amount of $5 million. To Lawrence Paul Visosky, if he survives me, $10 million. To Bella Klein, if she survives me, $3 million. To Luciana A. Fontanilla Jr., if he survives me, $3 million. To Merwin Dela Cruz, if he survives me, $3 million. To Gladstone Vieira Cochin, if he survives me, $5 million. To Ghislaine Maxwell, if she survives me, $10 million. To Anne Rodriguez, if she survives me, the amount of $5 million. To Redacted, if she survives me, $3 million. To David Rogers, if he survives me, $4 million. To Peter Saint-Amour, if he survives me, $1 million. To Dupsen du Lissant, if she survives me, $1 million. To Pierre Jules, if he survives me, $1 million. To Cecil de Jong, if she survives me, $1 million. To Jean Weibrocht, if she survives me, $1 million. To Jermaine Ronan, if she survives me, $1 million. To Daphne Wallace, if she survives me, $1 million. To Redacted, if she survives me, $2 million. To Redacted, if she survives me, $3 million. To Bryce Gordon, if he survives me, $2 million. To Redacted, if she survives me, $2 million. To Redacted, if she survives me, $1 million. To Redacted, if she survives me, $5 million. To Edward Rowan Larson, if he survives me, $5 million. To Martin Novak, if he survives me, $5 million. To Arlene Toilo, if she survives me, $1 million. To Carlos Toilo, if he survives me, $1 million. To Redacted, if she survives me, $5 million. To Una Pascal, if she survives me, $1 million. To Mark Epstein, if he survives me, the sum of $10 million to be held for him in trust to benefit his children. To Perry Bard, if she survives me, $3 million. To Redacted, if she survives me, the sum of $3 million. Thank you guys very much.
In 2019, the FBI put out a tip line for victims and anyone that had information about Jeffrey Epstein or Ghislaine Maxwell. And I called that tip line in September of 2019. And I told them not only about my story that happened back in July of 1991, I told them about the woman that brought me to Jeffrey, the woman that I knew worked for him for about 10 years throughout all of the 90s. I would later learn that she had actually stayed and was still working for him off and on for almost 20 years. That felt like a pretty hot tip to give the FBI. No one followed up with me. I kept continually calling the FBI, Southern District of New York, and the Detective Walter Harkins, who was with the NYPD sex trafficking force that was calling back people that had given tips. For a year and a half, I did that, until finally an FBI agent took my statement, sat on the phone with me for over an hour, took my statement, even said that that never should have happened, that somebody should have followed up with me. And then I never heard from that FBI agent again. So when we talk about investigative leads, we were giving them. Here's another one. This is a text message, October 15th. I don't know what year, because it doesn't say, but it's a text message that was cited in 13 different reports. Hi. And it's to Leon Black. Hi. I would like to have a copy of the NDA I signed. Can you please email it to me? Redacted. Thank you. Tuesday, October 16th, 12:59 p.m. Leon, you sexually harassed me, sex trafficked me, raped me, and eventually blacklisted me. I don't know for how much longer it will take me on my own to process the pain you caused me and my family. The least thing you could do is give me that document that I was forced to sign under duress and wasn't able to read before signing. Unfortunately, I'm still tied to you. I don't know if this is the same person, but take a listen. July 24th, Friday, 2015. This is from Jeffrey to a Russian email. How are you? I need a favor. There is a Russian girl from Moscow, redacted. She is attempting to blackmail a group of powerful businessmen in New York. It is bad business for everyone involved. She arrived in New York Saturday of last week, staying at the Four Seasons on 57th Street. Suggestions. No response was included in the files. August 16th, 2015. She's returning to the Gansevoort Hotel. That's from Brad Karp, an attorney for Epstein. Jeffrey writes back to him, what do we know about the weekend? Brad Karp writes back, I haven't gotten a report yet. Have you heard anything? And Brad tells him, or Jeffrey tells him, can you tell me? Can you tell me for certain that if Leon decides enough is enough, she has not responded to an email from him that says I'm checking on you, that you and Lauren can have her arrested, fed extortion, high bail, maybe deportation if she does not respond to his email, and shops for attorneys telling each one a horror story. He will be a target for a long time. In many cases that I've read, two things pop out. Some survive an MTD, bad for Leon, and some, if not most all, claim she has filed suit because I refuse to be extorted. I think the extortion claim after a filing is fairly weak and would be seen to be an intimidation tactic from a powerful man. If you think you are being extorted, like the two Jills in Miami, they went right to the police, and the dynamic energy is on the side of the good guys. Brad writes to Epstein, I'll check with Lauren, but my strong belief is the answer is yes, especially with the referral coming from the most recent head of Southern District, New York, U.S. State Attorney's Office. Jeffrey to Brad on August 16th. And
Do you add the visa under false pretense that Lauren quoted? Does not seem to be used very often for this type of thing. Maybe some sample cases, their timing and dispositions. Brad Karp to Jeffrey, checking with Lauren since this is his wheelhouse. Jeffrey to Brad, hunch, 82 Rose Hill Road, Watermill, if they don't have her. Thanks. What do we know since she left the lunch? Surveillance, transcript, any luck? That's Jeffrey to Brad. Brad writes back to Jeffrey, Gigi is in Moscow. This transcript should be completed tomorrow. I'll send it to you as soon as I received it. Jeffrey to Brad, did you get a report on where she went after lunch? Details? August 23rd, Brad to Jeffrey, to the CeeLo apartment building on 83rd in York, where she stayed until she traveled to JFK. She was snuck out through the garage in a car with tinted windows, and we have license plate numbers. Jeffrey to Brad, maybe Larissa Posner, quantitative hedge fund? Jeffrey to Brad, is she still being surveilled if she's still in London? Leon wants to nail down the fact that she is a pro. I have a name I can't figure out. Use Russian contacts. From Brad to Jeffrey, I'll check again with Lauren. My strong belief is the answer is yes, especially, that's a repeat. I have same 2 pages. Sorry for the delay. We stopped the surveillance on Friday. She was in London then, and we're not aware that she left. We can follow up on the prostitution front, but we haven't found any evidence yet. Let me read that again. We can follow up on the prostitution front, but we haven't found any evidence yet. Jeffrey to Brad. Can you have Lauren or someone actually determine the likelihood of bringing a real case against her in either London or New York? So far, I have not seen anything concrete. Leon thinks a case viable in London. Too much riding on that fact for it to not be non-feasible through technical possibility. Though technically possible. From Brad to Jeffrey. We can't bring a private case against her in New York, only London, and even in London, it's very tricky. Our London lawyer says she likely will lose a criminal trial for blackmail, though it's certainly not my preferred outcome. Jeffrey to Brad, can we have a conference call with you and the London lawyer tomorrow? That was in September of 2021. And everybody wonders why survivors don't come forward.
To the survivors, thank you all so much for being here, for your bravery, and for the truth that you speak. You are the reason we are all here and why we will be here for the next 23 hours raising money for World Without Exploitation. I am now joined by our first guest reader, Jennifer Welch, the co-host of the I've Had It podcast. Jennifer, thank you so much for joining me today during this 24-hour live. Why was it important for you to be here today?
I think it's important that any time we see an injustice, that we continue to shine a light on it. And the fact that the President of the United States is mentioned so much in these files, and it appears as though, in my opinion, a cover-up is taking place, I think that's all the more reason to continue shining the light.
I couldn't agree more. So I'll let you get to it. Thank you for being here.
Thank you. Okay, hello everyone. I'm going to read from volume 31 of 3,437. So if you look at the scale of this, it's probably close to 3 inches. And this is just 31 of 3,437. And the first page, it looks like an email. From is completely redacted, and to Jason Foy, F-O-Y, The subject is U.S. versus Noel, number 19, CR 830, Discovery Production 7. It's dated Wednesday, the 14th of April, 2021 at 13:44. And it has some attachments from SDNY and a discovery letter. And it says, Counsel, please find attached a letter regarding the government's production in this case. We are uploading a zip file containing the discovery materials to USA FX. Additionally, please find one additional page of discovery which has been marked Attorney's Eyes Only. Please contact us with any questions or if you have any difficulty accessing the production. Regards. And this is from a paralegal specialist. The name is redacted, from the U.S. Attorney's Office in the Southern District of New York. And then they have the protected materials. It looks like this is one of the attachments from SDNY. And it has employees' names. And I don't know if I should read their names or not, so I'm going to skip over that. And the next page is from the United States Department of Justice, from the United States Attorney's SDNY office, dated April 14th, 2021, to Jason E. Foy of Foy and Suplowitz, LLC. Dear Counsel, this letter provides additional discovery pursuant to Rule 16A of the Federal Rules of Criminal Procedure. This letter and the materials identified herein are subject to the protective order entered in this case on December 16th, 2019, and have been designated protected materials as defined in the order where noted below. Accordingly, the materials and information identified herein shall not be disclosed to any third party or referenced publicly except as set forth in the protective order. The description is arrest documentation and signed warrants, and it says the classification is confidential. Another item is documents from the MCC, including quarters, maps, and rosters, is classified as confidential. FBI import forms from SDNY is classified as confidential. FBI laboratory examination requests from the SDNY classified as confidential. FBI process reports from the SDNY classified as confidential. Witness statements from SDNY classified as confidential. Anonymized index from SDNY, and it's classified as Attorney's Eyes Only. It goes on to say, additionally, the government is producing the following materials only to your client: the U.S. Marshal Service intake and personal history from SDNY, and the classification is left blank. The email goes on to say, finally, we do not agree these materials are required to be produced pursuant to Rule 16 based on your prior request for information. The government is providing the following information from the Bureau of Prisons. Since approximately January 1st, 2019, in BOP, and I assume that's Bureau of Prisons, matters that resulted in sustained administrative charges of falsification with regards to log entries. The following disciplinary actions were taken: 2 letters of reprimand, 50 suspensions, 1 demotion, 3 terminations, and 6 resignations/retirements prior to discipline. The Bureau of Prisons has records of the following inmate deaths over the last 10 years at the MCC and the MDC. Tony McClam, date of death September 24, 2020, at the MCC. The death location was in the housing unit. Cause of death is cardiac. Kenneth Hook, date of death May 19th, 2020. The institution is MDC. The death location is the Special Housing Unit, and the cause of death is hanging. Eric Manson, date of death October 23rd, 2019, at the MCC. Death location is at the community hospital. The cause of death is drug overdose. Jeffrey Epstein, date of death August 10th, 2019. He was in the MCC. Death location is noted as community hospital. Cause of death is hanging. Oscar Reynoso, date of death 10/23/2015 at the MDC Community Hospital. Cause of death hanging. And Fang Shen-He, date of death July 19th, 2012 at the MDC. The death location is noted at the mental health unit, and the cause of death is hanging. The email goes on to say, the foregoing information is subject to the protective order. Please contact us with any questions. Very truly yours, Audrey Strauss, United States Attorney for the Southern District of New York. And then it says who wrote the email, and that is redacted. Going on to page 5, it's an email, and who it's from is 2 different people, and those names are redacted. Who it's to is to 4 different people, and those names are redacted. It is CC'd to 6 people, and all of those 6 people are redacted. The subject is forward, United States versus Ghislaine Maxwell, 20 CR 330 AJN, pretrial motion, reply, memoranda, and exhibits to be filed under seal. The date of this email is Tuesday, the 16th of March, 2021, and it has some attachments, some GIF files, zip files, and it looks like 3 JPEG files. And this just says FYI, and it's been forwarded to, so all of the names in the previous email are redacted. It's been forwarded to Christian Everdell, sent Monday, March 15th, 2021, to Nathan at NYSD Chamber, and then copied to 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 people who are redacted. The subject is United States versus Ghislaine Maxwell, pretrial motion, reply, memoranda, and exhibits to be filed under seal. Dear Judge Nathan, as set forth in the attached cover letter and pursuant to Rule 2B of the court's individual rules, attached for the court and government are 2 versions, redacted and unredacted, of Ms. Maxwell's reply, memoranda, in support of her pretrial motions and accompanying exhibits. A redacted cover letter is being filed on the public docket. Regards, Christian R. Everdell, Cohen and Gresser, LLP. And then moving along to page 7, this looks like a letter via electronic filing, perhaps, from Cohen and Gresser, LLP, and it's dated March 15th, 2021. It's addressed to the Honorable Allison J. Nathan, United States District Court, Southern District of New York, regarding United States versus Ghislaine Maxwell. Dear Judge Nathan, on behalf of our client, Ghislaine Maxwell, we will be filing the following reply memoranda with accompanying exhibits. Number 1, reply memorandum in support of motion to dismiss the superseding indictment for breach of the non-prosecution agreement. Number 2, reply memorandum in support of motion to dismiss counts 1 through 4 of the superseding indictment as time barred.
Number 3, reply memorandum in support of motion under the Due Process Clause to suppress all evidence obtained from the government subpoena to, and it looks like the name is redacted, and to dismiss counts 5 and 6. Number 4, reply memorandum in support of motion to dismiss counts 5 and 6 of the superseding indictment because the alleged misstatements are not perjurious as a matter of law. Number 5, reply memorandum in support of motion for a severance of and separate trial on counts 5 and 6 of the superseding indictment. Number 6, reply memorandum in support of motion to strike surplusage from the superseding indictment. Number 7, reply memorandum in support of motion to dismiss counts 1 through 6 of the superseding indictment for pre-indictment delay. Number 8, reply memorandum in support of motion to dismiss either count 1 or count 3 of the superseding indictment as multiplicitous. Number 9, reply memorandum in support of motion to dismiss the superseding indictment as it was obtained in violation of the 6th Amendment. Number 10, reply memorandum in support of motion for a bill of particulars and pretrial disclosures. Page 2 of this letter to the judge. Number 11, reply memorandum in support of motion under the 4th Amendment, Martindale, and the 5th Amendment to suppress all evidence obtained from the government subpoena to, and the name is redacted, and to dismiss counts 5 and 6. Number 12, reply memorandum in support of motion to dismiss counts 1 through 4 of the superseding indictment for lack of specificity. Several of the reply memoranda reference or discuss confidential information produced in discovery and are therefore redacted pursuant to paragraph 15 of the protective order, docket 36. In order to give the government the chance to review the proposed redactions, we will not file on the public docket any reply memoranda that contain redactions until we are instructed to do so by the court. The remaining reply memoranda do not contain any redactions. However, we are mindful of the fact that the government's omnibus memorandum in opposition to the defendant's pretrial motions to which the reply memoranda respond has not yet been filed on the public docket. Accordingly, we will also refrain from filing the reply memoranda that do not contain redactions on the public docket until we are instructed to do so by the court. Instead, we will submit by email to the court and the government all of the reply memoranda and exhibits pursuant to Rule 2B of the court's individual rules of criminal practice. For the reply memoranda and exhibits that contain redactions, we will submit 2 versions, an unredacted original to be kept under seal, and a version for public filing with proposed redactions. Please contact us with any questions. Your consideration is greatly appreciated. Respectfully submitted, Christian R. Everdell, Cohen, and Gresser, LLP. And it says that all counsel of record was CC'd via email. Moving along to page 9, we have an email from, and it is redacted, to, it is completely redacted, and the subject is forward, Jeffrey Epstein, Freedom of Information Cases, time-sensitive ISO. The date is Wednesday, the 17th of March, 2021. And it's from redacted to redacted, and it says, if you have or had one, please let me know ASAP. I already have blank, that's redacted, case before PAE. Thanks. And then it notes that it was sent from my iPhone. And then on page 10, it is from two redacted people to two redacted people. The subject is question regarding Epstein relativity. The date is Wednesday, the 17th of March, 2021, and the page is completely blank. Page 11. It's a copy of an email from two redacted names to two redacted names. The subject is GM suppression replies. It's dated Wednesday, the 17th of March, 2021, and has a lot of different attachments. And the email is redacted. It looks like maybe just 2 or 3 words. And it looks like it's from the Assistant United States Attorney, United States Attorney's Office, Southern District of New York, 1 St. Andrews Plaza, New York, New York, 10007. The telephone number is redacted. Page 12 is a copy of an email from, it looks like multiple people are redacted, and it looks like multiple people are CC'd, and it's all redacted. The subject is regarding Epstein victim call. It's dated Wednesday, the 17th of March, 2021, and it is addressed to H, and then the rest of the name is redacted, and then the next name is completely redacted, and then a redacted name says, got a third call from this person. Could you please let us know the status of your outreach to her? Thanks. And whoever signed the email, that name is redacted. It goes on to another email from, person's name is redacted, to, looks like 5 or 6 people. They're all redacted. And at least 2 people were CC'd, all redacted, dated Wednesday, March 10th, 2021. This is regarding the Epstein victim call, and it says, hi, blank and blank, both names redacted. A redacted name checked in with us to tell us that this person called him again. Could you please let us know the status of your outreach to her? Thanks very much. And then that person's name is redacted. Another email, same subject, the from, the to, and the CCs are all redacted. The subject is the Epstein victim call. It says, hi, blank and blank. Please see below. Would someone at the FBI be able to contact this woman for initial screening, please? Per our usual practice, if the screening suggests she may have useful information for our investigation, we can schedule an interview with the team. Thanks. And it looks like continuing in the same email chain, from, names are redacted, to, looks like at least 5 people are redacted. At least 2 people are CC'd on this. They are also redacted. Still the same subject, the Epstein victim call. Team, I just received a call on my desk line from a woman named blank, her name's redacted, who identified herself as a former client of redacted name and said she was a former victim of Jeffrey Epstein. I asked if her attorney had been in touch with either the prosecutors or the case agents since we had previously contacted him, and she said she believed he had not been. She said she had been in touch with an NYPD detective but had not heard back in some time. She said blank, a redacted name, represented her for purposes of the victim fund but was not currently representing her. She provided her cell phone as redacted. She did not provide any substantive information on the call, and I did not ask for any. I advised that someone would follow up with her, hopefully in the next week or so. The call lasted less than 3 minutes. For context, we were in touch with Mr. Redacted several times in 2020 when he claimed to represent at least 9 Epstein victims, all of which he said were unwilling to speak to us. He subsequently said one victim might be willing to speak with us, but then stopped responding to our request for the complaints he had purportedly filed, but which we couldn't find online. I believe the last communication we had with him was the attached Thanks. The name is redacted. This person is from the Assistant U.S. Attorney's Office in the Southern District. Page 14 is another email from redacted 2 people to redacted 4 people. The subject is regarding Maxwell Review, dated Wednesday, the 17th of March, 2021. The email reads, "Great, thanks." Another email, same thread, same redacted names. FYI, no pushback from blank. The name is redacted. Same thread from Edward Tyrell of the USA NYS. It's sent on Wednesday, March 17th, 2021 to 4 people. Their names are redacted. 2 people are CC'd. Their names are redacted. And they respond, "Got it." Then the same thread, all still the same redacted names. "Hi, blank and blank. Just want to put an issue on your radar. As you may recall, we paid a vendor to scan the SDFL Epstein file in October, and we are hopeful that it will be loaded into the relativity by the end of March. The delay was unfortunate, but we're hopeful PAE can make it happen soon. In order to meet pre-trial disclosures deadlines, we need to review the file, which we understand to be 30,000 documents, to determine what has already been produced. We have recruited 4 paralegals and an intern in PC to help conduct this review and have requested an additional 3 to 4 paralegals from Darcy to assist. The deadline is the end of April, so the team has about a month to complete the review. Happy to discuss any further if you have any questions. Thanks very much." The name is redacted, but they are from the Deputy Chief Public Corruption Unit in the U.S. Attorney's Office in the Southern District of New York. All right, page 15. From 2 redacted names to Marion Wang, another redacted name. It is CC'd to Gloria Allred and another redacted name. The subject is regarding another survivor. The date is Thursday, the 18th of March, 2021. That should work, thanks. Mind sending me the names and email addresses of participants, please. Miriam Wang, this email is from two redacted names, CC'd Gloria Allred, and she says, sure. How about April 2nd at 12:30 p.m.? 2 redacted people respond, hi, Marion, hope you are well too. Thanks. April 1 is pretty full on my end now. Would April 2 work for an interview with this survivor, please? Thanks. The name is redacted. It goes on from the original message from Marion Wang to 3 redacted people and Gloria Allred. I hope you're well. We have another survivor who would like to share her information, what happened to her. If you're willing, open, perhaps we could just add her to April 1st or let us know what you prefer. She is someone who was abused by Epstein on one occasion in 2004. Thank you, Marianne. And now we're getting to page 16, and this looks like an exhibit, a court document that says, in the United States District Court for the Southern District of New York, Radar Online LLC and James Robertson are the plaintiffs versus the Federal Bureau of Investigation is the defendant. And the next page looks like an online form that was sent out through the Freedom of Information Act that was requested April 20th, 2017. And the organization name is the National Enquirer. The name is, first name is James, the last name is Robertson. And then it has his email and his phone number. I'm not going to share that. And the location is the United States. It goes on to have the domestic address for, I believe, the National Enquirer. And it asks, how will you pay? And this person says, I'm requesting a fee waiver for my request and have reviewed the Freedom of Information Reference Guide. If my fee waiver is denied, I'm willing to pay additional fees that will enter that maximum amount in the box below. Allow up to $99,999. The National Enquirer does a waiver explanation, and it says the National Enquirer is a news organization under 5 USC 552. The Enquirer is entitled to a fee waiver because disclosure of the information sought is in the public interest, is likely to contribute significantly to public understanding of the operations or activities of the government, and is not primarily in the commercial interest of the requester. The non-individual Freedom of Information request, please see attached PDF for the National Enquirer's Freedom of Information request concerning the investigation and prosecution of financier Jeffrey Epstein in 2005 and 2006 for crimes relating to sexual trafficking of minors. And then they've requested that this be expedited, and the expedite reason is this request has been the subject of the request is of widespread and exceptional media interest, and the information sought involves possible questions about the government's integrity, which affects public confidence, specifically the issue of whether Mr. Epstein's wealth and connections secured him favorable treatment by the DOJ. Given that a civil defamation trial between one of Epstein's victims and his alleged co-conspirator, Ghislaine Maxwell, has just begun, the topic is of renewed interest to the public and therefore is worthy of expedited processing. Page 19, we have a letter from the National Enquirer letterhead to the Federal Bureau of Investigation from James Robertson, the senior managing editor of the National Enquirer. It says, Dear Sir or Madame, I am a reporter and editor for the National Enquirer. I request records under the provisions of the Freedom of Information Act 5 USC 552. Request. The Enquirer seeks all documents relating to the FBI's investigation and prosecution of financier Jeffrey Edward Epstein, who pled guilty to one count of felony solicitation of prostitution in August of 2006. Background. Jeffrey Epstein is a billionaire, financier, philanthropist, and sex offender. In 2005, Epstein became the subject of an undercover sex trafficking investigation by Palm Beach, Florida police and the FBI. Dozens of underage women claimed that they had been trafficked by Epstein to perform sexual acts on him as well as his friends. Many prominent political figures have been connected to Mr. Epstein's child trafficking ring, including former President Bill Clinton and Prince Andrew of the British royal family. Despite the gravity of his offenses, the Department of Justice agreed to allow Epstein to plead guilty to a single count of soliciting prostitution from an underage girl under Florida state law and served only 13 months in prison. In addition, prosecutors agreed not to bring charges against Epstein's alleged co-conspirators. I think that is okay.
Jen, thank you so much. We really appreciate you. Yes? So everyone, joining me now is independent journalist, a dear friend of mine, and the incredible Aaron Parnas. He is host of the Parnas Perspective, and he has done extensive reporting on the Epstein files, has done extensive advocacy for the survivors. And so, Aaron, I'm going to turn it over to you. Thank you for being here and for all you have done to stop people from turning away from the Epstein files. Thank you.
Today is an important day. Now in the moment, a lot of people have forgotten about ordinary yet in such a fast-paced called 27 cycle. The legacy has just the whole because for 1,000 survivors.
She is guys reporting the Epstein files because of the birth and
fully lies in the emphasis background. The facts called for affidavits, its depositions, and to interrogate and reasonably for the purpose of motions are as follows. Between 1997 and 2007, Jeffrey Epstein sexually abused more than 30 minor girls, including petition Jane Doe 1 and Jane Doe 2 after his mansion in Palm Beach, Florida, elsewhere in the United States, overseas. Because Epstein and his conspirators knowingly travel in interstate international commerce, sexually abused Jane Doe 1, Jane Doe 2, and others, they commit violation not only of law, but also federal law. In addition to his own abuse of victims, and direct other persons to abuse girls sexually, and used hate pleas to find and bring minor girls to him. Epstein worked in concert with others to obtain minors not only for the sexual gratification, also for the sexual gratification of others. In 2005, the town of Palm Beach Police Department received a complaint from the parents of a 14-year-old girl about her sexual abuse by Jeffrey Epstein. The PBPD ultimately identified approximately 20 girls between the ages of 14 and 17 sexually abused by Epstein. In 2006, as a result of the PBPD, Federal Bureau of Investigations, the FBI, opened an investigation into allegations that Epstein, as first assistants, used a facility in interstate commerce to induce girls between the ages of 14 and 17 to engage in illegal sexual activities. The FBI ultimately determined that both Jane 1 and Jane 2 were victims of sexual abuse by Epstein while they were minors. Jane 1 provided information about her abuse, and Jane used to the FBI on August 7, 2007. From January 2007 through September 2007, discussions took place with the U.S. Attorney's Office for the Southern District of Florida, Jeffrey Epstein's attorneys. On February 2007, Epstein sent a 24-page letter to the office going over what he intended to present at the office that day. By March 15, 2007, the office sent the letters to the victim informing them of their rights pursuant to the Crimes Victims' Rights Act, also known as CVR. In May of 2007, the office had drafted an 82-page prosecution memorandum, a 53-page statement outlining numerous federal sexual offenses committed by Epstein. On or June 7, 2007, FDA to Jane Doe a standard CVRA notification letter. The notification promised that the Justice Department would make best efforts to protect one's rights, including the reasonable right to confer with the attorney for the United States.
Of live streaming, we are having some technical difficulties with Aaron, but thankfully we are here inside of the Donald J. Trump and Jeffrey Epstein reading room, and we are now joined by Ellie Leonard, who has also reported extensively on the Epstein files. Ellie, thank you so much for being here.
Hi, my name is Ellie Leonard, and I am a writer and independent journalist. I don't know if I'd say the pleasure, but I had the chance to work on part of the Weinstein case, and as well as some of the Woody Allen story in my history as a small business owner, and that kind of led me to this moment. So I am going to read some of the files, and off we go. Should I get started? All right. So I'm going to turn a page here. Okay. This letter is from the FBI, dated April 28, 2017, from a Mr. James Robertson of the National Enquirer, second floor. Sorry, this is to James Robertson, second floor, 4 New York Plaza, New York, 10004. This says a FOIA FOIPA request number 1372398-000, subject Epstein Jeffrey. To Mr. James Robertson. Dear Mr. Robertson, this acknowledges receipt of your Freedom of Information Act FOIA request to the FBI. The FOIPA number listed above has been assigned to your request. You submitted your request via the FBI's eFOIA system. The box that has been checked says, we have reviewed your request and determined that it is not in compliance with the terms and conditions of the eFOIA system. Future correspondence will be mailed to you. You have requested records concerning one or more third-party individuals. The FBI recognizes an important privacy interest in the requested information. To continue processing your request regarding a third party, submit one of the following. 1. An authorization and consent from the individuals, i.e. express authorization and consent of the third party. 2. Proof of death, i.e. proof that your subject is deceased. Or 3. A justification that the public interest in disclosure outweighs personal privacy, i.e. a clear demonstration that the public interest in disclosure outweighs personal privacy interests. In absence of such information, the FBI can neither confirm nor deny the existence of any records responsive to your request, which, if they were to exist, would be exempt from disclosure pursuant to FOIA exemptions B6 and B7C, 5 U.S.C. 552, B6, and B7C. Express authorization and consent. If you seek disclosure of any existing records on this basis, enclosed is a certification of identity form. You may make additional copies of this form if you are requesting information on more than one individual. The subject of your request should complete this form and then sign it. Alternatively, the subject may prepare a document containing the required descriptive data and have it notarized. The original certification of identity or notarized authorization and the descriptive information must contain a legible original signature before FBI can conduct an accurate search of our records. Proof of death. If you seek disclosure of any existing records on the basis, proof of death can be a copy of a death certificate, Social Security death index, obituary, or another recognized reference source. Death is presumed if the birth date of the subject is more than 100 years ago. Public interest disclosure. If you seek disclosure of any existing records on this basis, you must demonstrate that the public interest in disclosure outweighs personal privacy interests. In this regard, you must show that the public interest sought is a significant one, and that the requested information is likely to advance that interest. Fax your request to the Works Process Unit at 540-868-4997 or mail to 170 Marcel Drive, Winchester, Vermont, 22602. If we do not receive a response from you within 30 days of the date of this letter, your request will be closed. You must include the FOIPA request number with any communication regarding this matter. For your information, Congress excluded 3 discrete categories of law enforcement and national security records from the requirements of the FOIA. See 5 U.S.C. 552C. As such, this response is limited to these records, if any exist, that are subject to the FOIA. This is a standard notification that is given to all our requesters and should not be taken as an indication that excluded records do or do not exist. You may file an appeal by writing to the Director, Office of Information Policy, OIP, United States Department of Justice, Suite 11050, 1425 New York Avenue, Northwest, Washington, D.C., 20530-0001. Or you may submit an appeal through OIP's FOIA online portal by creating an account on your following site. They give the website. Your appeal must be postmarked or electronically transmitted within 90 days from the date of this letter in order to be considered timely. If you submit your appeal by mail, both the letter and the envelope should be clearly marked Freedom of Information Act appeal. Please cite the FOIPA request number assigned to your request so that it may be easily identified. You may seek dispute resolution services by contacting the Office of Government Information Services or by emailing, gives the email. Alternatively, you may contact the FBI's FOIA Public Liaison by emailing, gives the email. If you submit your dispute resolution correspondence by email, the subject heading should clearly state Dispute Resolution Services. Please also cite the FOIPA request number assigned to your request so that it may be easily identified. For questions on how to reasonably describe your request, please email us, gives the email. You may also visit www.fbi.gov and select Services, Record Management, and Freedom of Information Privacy Act for additional guidance. Enclosed for your information is a copy of the FBI fact sheet and a copy of the explanation of exemptions. Sincerely, David M. Hardy, Section Chief, Record Information Dissemination Section, Records Management Division, includes enclosures. FBI fact sheet, turning the page. The primary functions of the FBI are national security and law enforcement. The FBI does not keep a file on every citizen of the United States. The FBI was not established until 1908, and we have very few records prior to the 1920s. FBI files generally contain reports of FBI investigations of a wide range of matters, including counterterrorism, counterintelligence, cybercrime, public corruption, civil rights, organized crime, white-collar crime, major thefts, violent crime, and applicants. The FBI does not issue clearances or non-clearances for anyone other than its own personnel or persons having access to FBI facilities. Background investigations for security clearances are conducted by many different government agencies. Persons who receive a clearance while in the military or employed with some other government agency should contact that entity. Most government agencies have websites which are accessible on the internet which have their contact information. An identity history summary check, or rap sheet, is not the same as an FBI file. It is a listing of information taken from fingerprint cards and related documents submitted to the FBI in connection with arrests, federal employment, naturalization, or military service. The subject of a rap sheet may contain a copy by submitting a written request to FBI CJIS Division Summary Request, 1000 Custer Hollow Road, Clarksburg, West Virginia 26306. Along with a specific written request, the individual must submit a new full set of his or her fingerprints in order to locate the record, establish positive identification, and ensure that an individual's records are not disseminated to an unauthorized person. The fingerprint submission must include the subject's name, date, and place of birth. There is a required fee of $18 for this service, which must be submitted by money order or certified check made payable to the Treasury of the United States. A credit card payment option is also available. Forms for this option and additional directions may be obtained by accessing the FBI website. The National Name Check Program, NNCP, conducts a search of the FBI's Universal Index, UNI, to identify any information contained in FBI records that may be associated with an individual and provides the results of that search to the requesting federal, state, or local agency. Names are also searched in a multitude of combinations and phonetic spellings to ensure all records are located. The NNCP also searches for both main and cross-reference files. The main file is an entry that carries the name corresponding to the subject in the file, while a cross-reference is merely a mention of an individual contained in a file. The results from a search of this magnitude can result in several hits and idents on an individual. In each instance where UNI has identified a name variation or reference, information must be reviewed to determine if it is applicable to the individual in question. The Records/Information Dissemination Section, RIDS, searches for records and provides copies of FBI files responsive to Freedom of Information or Privacy Act, FOIPA, requests for information. RIDS provides responsive documents to requesters seeking reasonably described information. For an FOIPA search, the subject's name, event, activity, or business is searched to determine whether there is an associative investigative file. This is called a main file search and differs from the NNCP search. For general information about the FBI, visit our website at fbi.gov. Okay. Explanation of exemptions. Subjects of Title V United States Code Section 552. B1A, specifically authorized under criteria established by an executive order to be kept secret in the interest of national defense or foreign policy, and B, are in fact properly classified to such executive order. B2, related solely to the internal personnel rules and practices of an agency. So these are exemptions for looking for things. B3, specifically exempted from disclosed by statute, other than Section 552B of this title, provided that such statute, A, requires that the matters be withheld from the public in such a manner as to leave no discretion on issue, or B, establishes particular criteria for withholding or refers to particular types of matters to be withheld. Trade secrets, B4, trade secrets and commercial or financial information obtained from a person and privileged or confidential. B5, interagency or intra-agency memorandums or letters which would not be available by law to a party other than an agency in litigation with the agency. B6, personnel and medical files and similar files, the disclosure of which would constitute a clearly unwarranted invasion of personal privacy. B7, records or information compiled for law enforcement purposes, but only to the extent that the production of such law enforcement records or information, A, could reasonably be expected to interfere with enforcement proceedings, B, would deprive a person of the right to a fair trial or an impartial adjudication, C, could reasonably be expected to constitute an unwarranted invasion of personal privacy, D, could reasonably be expected to disclose the identity of confidential source, including a state, local, or foreign agency or authority by any private institution which furnished information on a confidential basis, and in the case of record or information compiled by a criminal law enforcement authority in the course of a criminal investigation, or by an agency conducting a lawful national security intelligence investigation, information furnished by a confidential source, E, would disclose techniques and procedures for law enforcement investigations or prosecutions, or would disclose guidelines for law enforcement investigations or prosecutions if such disclosure could reasonably be expected to risk circumvention of the law, or F, could reasonably be expected to endanger the life or physical safety of any individual. B8, contained in or related to operating or condition reports prepared by, on behalf of, or for the use of an agency responsible for the regulation or supervision of financial institutions, or B9, geological and geophysical information and data, including maps concerning wells. Subsection of Title V, United States Code, Section 552A, D5, information compiled and reasonably anticipated of a civil action proceeding. J2, material reporting investigative efforts pertaining to an enforcement of criminal law, including efforts to prevent, control, or reduce crime or apprehend criminals. K1, information which is currently and properly classified pursuant to an executive order in the interest of the national defense or foreign policy, for example, information involving intelligence sources or methods. K2, investigatory material compiled for law enforcement purposes other than criminal, which did not result in loss of a right, benefit, or privilege held under federal programs, or which would identify a source who furnished information pursuant to a promise that his or her identity would be held in confidence. K3, material maintained in connection with providing protective services to the President of the United States or any other individual pursuant to the authority of Title 18, United States Code, Section 3056. K4, required by statute to be maintained and used solely as statistical records. K5, investigatory material compiled solely for the purpose of determining suitability, eligibility, or qualification of federal civilian employment, or for the access of classified information, the disclosure of which would reveal the identity of a person who furnished information pursuant to a promise that his or her identity would be held in confidence. K6, testing or examination material used to determine individual qualifications for appointment or promotion in federal government service, he released of which would compromise the testing or examination process. K7, material used to determine potential for promotion in the armed services, the disclosure of which would reveal the identity of the person who furnished the material pursuant to a promise that his or her identity would be held in confidence. The U.S. Department of Justice Certification of Identity. Privacy Act Statement. In accordance with 28 CFR Section 16.41d, personal data sufficient to identify the individual submitting requests by mail under the Privacy Act of 1974, 5 U.S.C. Section 552A is required. The purpose of this solicitation is to ensure that the records of the individuals who are the subject of the U.S. Department of Justice systems of records are not wrongfully disclosed by the Department. Requests will not be processed if this information is not furnished. False information of this form subjects the requester to criminal penalties under 18 U.S.C. Section 1001 and or 5 U.S.C. Section 552A I3. Public reporting burden for this collection of information is estimated to average 0.5 hours per response, including the time for reviewing instructions, searching existing data sources, gathering and maintaining the data needed, and completing and reviewing the collection of information. Suggestions for reducing this burden may be submitted to the Office of Information and Regulatory Affairs, Office of Management and Budget, Public Use Record Reports Project 1103-0016, Washington, D.C. 20503. And this is a form where they fill out the full name of the requester, the citizenship status, social security number, current address, date of birth, place of birth, and then optional, authorization to release information to another person. And then I declare under penalty of perjury, under the laws of the United States of America, that the foregoing is true and correct, and that I am the person named above, and I understand that any falsification of this statement is punishable under provisions of 18 U.S.C. Section 1001 by a fine of not more than $10,000 or by imprisonment of not more than 5 years or both, and that requesting or obtaining any records under false pretenses is punishable under the provisions of 5 U.S.C. 552AI3 by a fine of not more than $5,000, and then they sign and date. Okay. We're moving on to Exhibit C. In the United States District Court of the Southern District of New York, Radar Online LLC and James Robertson, plaintiffs, versus the Federal Bureau of Investigation, defendant, civil action number 1:17 CV 03956 PGG. This is a letter from the FBI to Mr. Daniel Novak on behalf of Radar Online. October 11th, 2017. Civil action number 17 CV 03956. FOIPA request number 1372398-000, subject Epstein, Jeffrey. Dear Mr. Novak, the enclosed documents were reviewed under the Freedom of Information Act, FOIA, Title V, United States Code, Section 552. Deletions have been made to protect information which is exempt from disclosure, with the appropriate exemptions noted on the page next to the excision. In addition, a deleted page information sheet was inserted in the file to indicate where pages were withheld entirely. The exemptions used to withhold information are marked below and explained on the enclosed explanation of exemptions. It goes through each section, and there's a check next to a box for all the sections that were missed. In accordance with standard FBI practice and pursuant to FOIA Exemption B7E and Privacy Act Exemption J25 U.S.C. 552552A, B7E/J2, this response neither confirms nor denies the existence of your subject's name on any watch lists. For your information, Congress excluded 3 discrete categories of law enforcement and national security records from the requirements of the FOIA. C5 U.S. C552C 2006 and Supplemental 4 2010. This response is limited to those records that are subject to the requirements of the FOIA. This is a standard notification that is given to all our requesters and should not be taken as an indication that excluded records do or do not exist. Enclosed for your information is a copy of the explanation of exemptions. Although your request is in litigation, we are required by 5 U.S.C. 552A6A to provide you the following information concerning your right to appeal. You may file an appeal by writing to the Director, Office of Information Policy, OIP, United States Department of Justice, Suite 11050, 1425 New York Avenue, Northwest, Washington, D.C. 20530-001. Or you may submit an appeal through OIP's FOIA online portal by creating an account on the following website, which it lists. Your appeal must be postmarked or electronically transmitted within 90 days from the date of this letter in order to be considered timely. If you submit an appeal by mail, both the letter and the envelope should be clearly marked. Freedom of Information Act appeal. Please cite the FOIPA request number assigned to your request so that it may be easily identified. See additional information which follows from David Hardy, Section Chief, Record-Information Dissemination Section, Records Management Division. The enclosures include: the enclosed documents contained in this release represent the first interim release of information responsive to your April 21, 2017 Freedom of Information Act, FOIA request. Duplicate copies of the same document were not processed. For your information, sealed court records are not eligible for release under the Freedom of Information Act, and material responsive to your request has been withheld and marked Other Sealed, pursuant to the appropriate orders issued by federal district courts. Your request for a waiver of fees has been granted. For questions regarding our determinations, visit the FBI.gov website under Contact Us. The FOIPA request number listed above has been assigned to your request. Please use this number in all correspondence concerning your request. Your patience is appreciated. They go through and they list the same page of exemptions that I just read, so I'm going to pass over that part. And, okay. We now have, for the same court case, Radar Online, LLC, and James Robertson, plaintiffs, versus Federal Bureau of Investigation, defendant, civil action number 117 CV 03956 PGG Exhibit D. Get some water. Okay. This is from the FBI to Mr. Daniel Novak on behalf of Radar Online, Law Offices of Daniel Novak in Madison, New Jersey, November 1st, 2017. Subject, Epstein, Jeffrey. This is a FOIPA request number 1372398-000. Dear Mr. Novak, the enclosed documents were reviewed under the Freedom of Information Act, FOIA. Title V, United States Code, Section 552. Deletions have been made to protect information which is exempt from disclosure, with the appropriate exemptions noted on the page next to the excision. In addition, a deleted page information sheet was inserted in the file to indicate where the pages were withheld entirely. The exemptions used to withhold information are marked below, explained on the enclosed explanation exemptions. They list the exemptions. 527 pages were reviewed and 25 pages are being released. In accordance with standard FBI practice and pursuant to FOIA Exemption B7E and Privacy Act Exemption J2 5 USC 552-552A B7E-J2, this response neither confirms nor denies the existence of your subject's name on any watch list. For your information, Congress excluded 3 discrete categories of law enforcement and national security records from the requirement of the FOIA. See 5 USC 552C 2006 and Supplemental 4 2010. This response is limited to those records that are subject to the requirements of the FOIA. This is a standard notification that is given to all our requesters, and should not be taken as an indication that excluded records do or do not exist. Enclosed for your information is a copy of the explanation of exemptions. Although your request is in litigation, we are required by 5 U.S.C. 552 A6A to provide you the following information concerning your right to appeal. You may file an appeal by writing to the Director, Office of Information Policy, OIP, United States Department of Justice, Suite 11050, 1425 New York Avenue, Northwest, Washington, D.C. 20530-0001. Or you may submit an appeal through the OIP's FOIA online portal by creating an account on the following website. They give the website. Your appeal must be postmarked or electronically transmitted within 90 days from the date on this letter in order to be considered timely. If you submit your appeal by mail, both the letter and the envelope should be clearly marked Freedom of Information Act Appeal. Please cite the FOIPA request number assigned to your request so that it may be easily identified. See additional information which follows. Sincerely, David Hardy, Section Chief, Record-Information Dissemination Section, Record Management Division. Enclosures. The enclosed documents contain the in this release represent the second interim release of information responsive to your April 21, 2017 Freedom of Information Act FOIA request. Duplicate copies of the same document were not processed. For questions regarding your determinations, visit the FBI.gov website under Contact Us. The FOIPA request number listed above has been assigned to your request. Please use this number in all correspondence concerning your request. Your patience is appreciated. They again include the explanation of exemptions. We have Exhibit E, Radar Online, LLC, and James Robertson, plaintiffs versus the FBI, defendant, civil action number 117, CV 03956PGG. This letter is to Mr. Daniel Novak on behalf of Radar Online, December.
Division. The enclosure is the enclosed documents contained in this release represent the 5th interim release of information responsive to your April 21st, 2017 FOIA request. For questions regarding our determinations, visit fbi.gov/FOIA under Contact Us and use the number listed above assigned to your request. Please use this number in all correspondence concerning your request. Then there is an explanation of exemptions. And then Exhibit H, which is a United States District Court for the Southern District of New York, civil action. It has a case number, and it is Radar Online LLC and James Robertson, plaintiffs, versus Federal Bureau of Investigation, defendant. Then there is another letter, which seems to be entirely duplicative of what I just read you, and I think is, it's another list of the explanations as well as the cover page for the civil action, which is Radar versus FBI. So I'm, I think that is, again, the same thing. And again, explanation of exemptions. This all seems to be duplicative. Q, R, T. No, this is exactly the same. But anyhow, I think we have our next guest visitor, but I'm still trying to get this to a page where if someone takes over, they won't read the exact same thing that I just read. I'm trying very hard. Okay. I will skip to right here. Okay.
I am Miles Taylor, the founder of Defiance.org. Very proud to join the reading today. I think this is extremely important. Before I jump into the next,
Miles, thank you so much for being here.
Before I jump into the next document, let me say this issue, the Epstein corruption, exemplifies the corruption of this current administration. That's why it's so important. And the next document I have here to read to you is a 2020 lawsuit from the U.S. Virgin Islands filed against Jeffrey Epstein's estate. Now, this document matters because it's the document that reframes the Epstein story. Instead of treating Jeffrey Epstein like a lone predator, this lawsuit from the government of the U.S. Virgin Islands argues that he ran an actual organization, a web of shell companies and trusts and planes and helicopters and 2 private islands, as many of you know, that existed to traffic and abuse women and girls, and which kept operating well after his 2008 conviction and continued during his friendship with the current president. It's also the case that clawed back about $105 million from his estate and laid the groundwork for the later lawsuits against JP Morgan and Deutsche Bank. In the Superior Court of the Virgin Islands, Division of St. Thomas and St. John, the government of the United States Virgin Islands plaintiff versus Darren K. Indike in his capacity as the executor for the estate of Jeffrey Epstein and administrator of the 1953 trust. Richard Kahn in his capacity as executor for the estate of Jeffrey E. Epstein and administrator of the 1953 trust. The estate of Jeffrey E. Epstein. The 1953 trust, Plan D, LLC, Greater St. Jim, LLC, Nautilus Incorporated, Hyperion Air, LLC, Poplar Incorporated, Southern Trust Company Incorporated, and John and Jane Doe's defendants. As you can see there, the suit shows just the surface of those different shell companies and entities that the government of the Virgin Islands had to pursue to go after Jeffrey Epstein's estate to get restitution for the victims. It continues. First amended complaint. Comes now the government of the United States Virgin Islands, hereinafter government, and files this first amended complaint against the above named defendants and in support thereof, which show unto the court as follows. Jurisdiction and parties. 1. The Attorney General of the United States Virgin Islands, hereinafter Virgin Islands, brings this action on behalf of the plaintiff, Government of the Virgin Islands, pursuant to 3 VIC Section 114, and her statutory authority to enforce the laws of the Virgin Islands and advocate for the public interest, safety, health, and well-being of persons in the Virgin Islands. 2. This court has subject matter jurisdiction over this civil matter pursuant to 4 VIC Section 76 and 14 VIC Section 607. 3. This court has personal jurisdiction over the parties pursuant to 5 VIC Section 4903. 4. The Virgin Islands is an unincorporated territory of the United States. It consists of St. Thomas, St. Croix, St. John, and Water Island, and more than 40 surrounding islands and cays, some of which are privately owned. Among these privately owned islands are Little St. James and Great St. James. 5. Jeffrey E. Epstein was a resident of the Virgin Islands, and he maintained a residence on Little St. James, which he acquired in 1998, and in 2016, he also purchased Great St. James. Epstein registered as a sex offender in the Virgin Islands in 2010. He was a Tier 1 offender under Virgin Islands law based on his Florida conviction of procuring a minor for prostitution. As a Tier 1 offender, Epstein was required to register annually with the Virgin Islands Department of Justice, the VIDOJ, and give advance notice of his travel to and from the Virgin Islands. Epstein was also subject to random address verification by the VIDOJ. 7. Epstein was found dead on August 10, 2019, while in custody in New York for sex crimes. 8. Defendant Darren K. Indyke, hereinafter Defendant Indyke, is co-executor of the estate of Jeffrey E. Epstein and administrator of the 1953 Trust. 9. Defendant Richard D. Kahn, Defendant Kahn, is co-executor of the estate of Jeffrey E. Epstein and administrator of the 1953 Trust. 10. Defendant, the estate of Jeffrey Epstein, created upon Epstein's death, is domiciled in the Virgin Islands. On August 15, 2019, defendants Indyke and Kahn filed a petition for probate and letters testamentary, which included Epstein's last will and testament, with the probate division of the Superior Court of the Virgin Islands. Okay, so this is Epstein, what he wanted to happen to his money and assets when he died. Obviously different than what the Virgin Islands is requesting. 11. The petition reports the value of the real and personal property in the estate located in the Virgin Islands of $577,672,654, more than $500 million in assets that Epstein owned upon his passing in the Virgin Islands. Number 12, according to the petition, the assets in the Virgin Islands thus far includes A, $56.5 million in cash, B, $127 million in fixed income and equity investments, C, $195 million in hedge fund and private equity instruments, and D, $18.5 million in planes, boats, and automobiles. The estate has not yet valued its fine arts, antiques, and other valuables. The estate also includes shares of various corporate entities which hold residences and real property used by Epstein, namely A, a brownstone in New York City valued at $56 million, B, a ranch in New Mexico valued at $72 million, C, a gated home in Palm Beach, Florida, not far from Mar-a-Lago, valued at $12 million, D, 7 units in an apartment building in Paris, valued at $8 million, and E, Great St. James and Little St. James, collectively valued at $86 million. 14. The estate is responsible to pay damages for the acts committed by Epstein and the Epstein enterprise described below. 15. Defendant, the 1953 trust, was created by Epstein, who, quote, amended and restated its terms only 2 days before his suicide. That same day, Epstein revised his last will and testament, transferring all of his property, real and personal, wherever situated, into this trust. 16. The trust also contains Epstein's financial assets and is also responsible to pay damages for the acts committed by Epstein and the Epstein enterprise described below. Defendants Indike and Khan filed a certificate of trust in the Superior Court of the Virgin Islands for the trust on August 26, 2019. 17. Epstein maintained a deliberately complex web of Virgin Islands corporations, limited liability companies, foundations, and other entities, not all of which are yet known to the government of the Virgin Islands, through which he carried out and concealed his criminal conduct. 18. Epstein regularly created new entities in the territory and transferred properties and funds between them in order to preserve and shield Epstein's assets and to facilitate and conceal the unlawful acts described in this complaint. 19. These entities held properties, including Little St. James and Great St. James, at which Epstein trafficked and sexually abused women and underage girls. Epstein owned and arranged for private planes, helicopters, boats, and automobiles to transport victims to, from, and within the Virgin Islands, and provided money to pay these young women and underage girls. 20. Epstein sat at the hub of this web, serving as president, member, manager, or director of each entity upon information and belief directing their activities. 21. Defendant Nautilus Incorporated is a corporation established and organized under the laws of the Virgin Islands. It was incorporated on November 22, 2011. 22. According to records of the Virgin Islands Recorder of Deeds, Nautilus Incorporated owns Little St. James, aka parcel number 109-803-010100, a parcel of 3.1 million square feet valued at $3.2 million, with buildings and improvements valued at $4 million. 23. Epstein was president and director of Nautilus Incorporated, which corporate filings describe as a holding property for personal use. Defendants Indike and Khan are the secretary and treasurer of Nautilus Inc., respectively. The estate values Epstein's holdings of Nautilus Inc., which holds title to Little St. James, at $63.9 million. 24. A deed recorded with the Virgin Islands Recorder of Deeds on December 30th, 2011 reflects that the property was transferred from a Delaware entity, LSJ LLC, to Nautilus Inc. for $10 and other good and valuable consideration. The quitclaim deed lists Jeffrey Epstein as the sole member of LSJ LLC, which it acquired Little St. James via a warranty deed dated April 27th, 1998. If you're having trouble following along, you can already see the complexity of these different shell organizations to transfer his assets. Number 25. As described below, Epstein engaged in a pattern and practice of trafficking and sexually abusing young women and female children on this private secluded island of Little St. James, where Epstein and his associates could avoid detection of their illegal activity from Virgin Islands and federal law enforcement and prevent these young women and underage girls from living freely and escaping the abuse. 26. Thus, Nautilus Incorporated participated in carrying out, facilitating, and concealing Epstein's crimes. Hence, Little St. James became an instrumentality of those crimes. 27. Defendant Great St. Jim LLC is a limited liability company established and organized under the laws of the Virgin Islands. Great St. Jim LLC was organized on October 26, 2015. According to records of the Virgin Islands Recorder of Deeds, it owns at least 3 properties that make up Great St. James, acquired on January 28, 2016. Parcel number 109-801-0101-0100, consisting of 3.5 million square feet and valued at $17.5 million. Parcel number 109-801-010200, consisting of 450,000 square feet of land, valued at $2.8 million. And parcel number 109-801-010300, 1.2 million square feet of land, valued at $2.7 million. According to a warranty deed filed with the Virgin Islands Recorder of Deeds, Epstein, through this entity, Great St. Jim LLC, acquired the last 2 parcels for $5 million each. Number 28. Epstein is listed as manager and member of Great St. Jim LLC, and the nature of its business is described as holding assets. Number 29. Upon information and belief, Epstein purchased these Great St. James properties, the island with closest proximity to Little St. James, to further shield his conduct on Little St. James from view, prevent his detection by law enforcement or the public, and allow him to continue and conceal his criminal enterprise. Epstein's significant investment in the purchase of Great St. James demonstrates his intent to expand his illegal operation in the Virgin Islands for years to come. Thus, Great St. Jim, LLC, participated in carrying out, concealing, facilitated, and continuing Epstein's crimes. And Great St. James became an instrumentality of those crimes. The document goes on to other entities involved in the abuse. Number 30, defendant, Poplar Incorporated, is a corporation established and organized under the laws of the Virgin Islands. Poplar Incorporated was incorporated November 22nd, 2011. Epstein was president and director of Poplar Incorporated, and its purpose was described in corporate filings as, quote, holding property for personal use. Defendants Indike and Khan are secretary and treasurer of Poplar Incorporated, respectively. A certificate of incumbency provided to the Department of Planning and Natural Resources also lists Epstein as president of Poplar Incorporated and expressly authorizes the incorporators to conduct, quote, transactions related to permitting matters submitted on behalf of Great St. Jim, LLC, unquote. Number 32. Poplar Inc. is listed as the signatory for the 2017 annual report for Great St. Jim, LLC, and the signature appears to be Jeffrey Epstein's. The petition for probate and letters of testamentary filed by the Epstein estate lists Poplar Incorporated as holding title to Great St. James. Thus, Poplar Incorporated participated in carrying out, concealing, facilitating, and continuing Epstein's crimes. Number 33. Defendant Plan D, LLC, is a limited liability company established and organized under the laws of the Virgin Islands. In its original articles of organization, filed October 19th, 2012, and its annual report filings, Epstein's pilot, Larry Vasosky, was listed as Plan D, LLC's sole manager and member. However, the July 31, 2019 annual report revealed Epstein as the principal behind Plan D, LLC. I'll share with you, that's only half of the document. This barely scratches the surface of this complex web that authorities have had to untangle to understand what Jeffrey Epstein and his associates were doing. Thank you to Save America Movement for their work on this reading and the Trump Epstein Memorial Reading Room.
Thank you so much, Miles. And we are now officially in our second hour of our 24-hour live stream, Cover to Cover Up, a public reading of the Epstein files from the Donald J. Trump and Jeffrey Epstein Reading Room in Lower Manhattan. We are raising money for World Without Exploitation. So thank you, everyone, for tuning in. Thank you for being here. And I am now joined by political strategist Steve Schmidt of The Warning. Steve is a member of the Save America Movement Steering Committee. Steve, why is this event so important to Sam? Oh, Steve is not with us yet. I apologize. This is the nature of live streaming for 24 hours. So let me actually just turn back to reading something while we wait on Steve, who I know is joining us momentarily. So I'm reading from a court order. This is the United States District Court from the Southern District of New York, the United States of America versus Ghislaine Maxwell, defendant. This is Allison J. Nathan, District Judge. On March 5th, 2021, defendant Ghislaine Maxwell submitted to the court an application for an order authorizing a subpoena pursuant to Rule 17c3 of the Federal Rules of Criminal Procedure. The proposed subpoena was directed at a law firm that represents alleged victims of the defendant. As is standard for Rule 17c subpoenas, the application was made ex parte and under seal on the ground that it reveals defense strategy. A number of court cases are cited. Rule 17c3 provides that, quote, after an indictment is filed, a subpoena requiring the production of personal or confidential information about a victim may be served on a third party only by court order, but before entering the order, and unless there are exceptional circumstances, the court must require giving notice to the victim so the victim can move to quash or modify the subpoena or otherwise object. I will get back into this shortly, and we will have other guest readers, but I do think right now we have Steve Schmidt joining us, so let me turn it over to him. I will get back into this shortly, and I will guest readers, but I do think right now we have, so let me turn it over to him. I will get back into this shortly, and I will guest readers, but I do think.
On March 19th, the line prosecutor sent a lengthy email to a prospective pro bono attorney for one of Epstein's victims who had been subpoenaed to appear at a deposition. The email listed the attorneys representing Epstein, the targets of the investigation, and recounted in detail the investigation that had been conducted to that point. The email did not reveal the fact that Epstein had signed the NPA in September 30, 2007. On May 30, 2008, Jane Doe 5, who was recognized as an Epstein victim by the office, received a letter from the FBI advising her that, quote, this case is already under investigation. This can be a lengthy process, and we request your continued patience while we conduct a thorough investigation, end quote. The May 30th, 2008 victim letter to Jane Doe 5 also acknowledged the victim's rights under the CVRA. In May 30th, 2008 victim letter to Jane Doe 5 also acknowledged the victim's rights under the CVRA. In
Looking.
I'm ready. All right, we're back. Let's see where I was exactly. So, consistent with the rule on March 12, 2021, in a sealed ex parte order, the court required defense counsel to provide notice to alleged victims whose personal or confidential information may be disclosed by the proposed subpoena. The court also gave the victims an opportunity to object or request modifications of the subpoena as required by Rule 17C3. You're ready to go back to Steve? Okay, so we are ready to go back to Steve Schmidt. We are live. Gotta love live events. We're doing great.
Steve Schmidt here. Pleasure to be joining in the reading this afternoon on this important issue, which is being swept under the rug and covered up by so much of the corporate media. In mid-June of 2008, Mr. Redacted, the attorney for petitioners, contacted the line prosecutor to inform her that he represented Jane Doe 1 and later Jane Doe 2. Redacted asked to meet to provide information about the federal crimes committed by Epstein against these victims. The line prosecutor and Redacted discussed the possibility of federal charges being filed in the future. Redacted was led to believe federal charges could still be filed, but no mention whatsoever of the existence of the NPA or any other possible resolution to the case. At the end of the call, the line prosecutor asked Redacted to send any information that he wanted considered by the office in determining whether to file federal charges. The line prosecutor did not inform Redacted about the NPA. On June 19, 2008, Redacted sent an email to the line prosecutor requesting to meet and discuss the plans. On June 23, 2008, the line prosecutor sent an email to Lefkowitz stating that the Deputy Attorney General had completed his review of the Epstein matter and determined that federal prosecutors of Mr. Epstein's case was appropriate. Accordingly, Mr. Epstein had until the close of business on Monday, June 30, 2008, to comply with the terms and conditions of the agreement between the United States and Mr. Epstein. On or about 27 June 2008, the office called Redacted to provide notice to his clients regarding the entry of Epstein's guilty plea in state court. According to Redacted, the line prosecutor only told him that Epstein was pleading guilty to state solicitation of prostitution. He was not told that the state plea was related to the federal investigation or that the state plea would resolve the federal crimes. Redacted claims he was not told his clients could address the state court. Redacted. In contrast, the line prosecutor claimed she told Redacted that his clients could address the state court. Redacted. On or before 30 June 2008, the office prepared a draft victim notification to be sent to the victims. The notification was designed to inform the victims of the provisions of the deferral of federal prosecution in favor of state charges. The notification letter began by describing Epstein's guilty plea in the past tense. On 30 June 2008, Jeffrey Epstein entered a plea of guilty to violations of federal statutes forbidding the solicitation of minors to engage in prostitution and felony solicitation of prostitution. Later, a substantively identical letter was prepared for Epstein and his counsel's review. On June 30, 2008, the office sent an email to Epstein's counsel, quote, "The FBI has received several calls regarding the non-prosecution agreement. I do not know whether the title of the document was disclosed when the agreement was filed under seal, but the FBI and our offices are declining comment if asked." That same day, Epstein pled guilty to state law solicitation of prostitution charges. Immediately following the 30 June 2008 hearing, the line prosecutor told one of the victim's attorneys that Epstein had pled guilty today in state court. Also after the plea, the line prosecutor emailed the assistant state attorney a copy of the NPA to be filed under seal. July 1st, 2008, email DE 362-38. On June 30, 2008, based on what had been told by the government, Jane Doe 1 thought that the office was still investigating and pursuing her case. She did not receive notice that Epstein's state guilty plea affected her rights in any way. If she had been told that the state plea had connections to blocking the prosecution of her case, she would have attended and tried to object to the judge to prevent the plea from going forward. According to line prosecutor, Redacted did not tell her that Jane Doe number 1 wanted to meet with her before a resolution was reached. Redacted. On July 3rd, 2008, as specifically directed by the office, Redacted sent a letter to the office communicating the wishes of Jane Doe number 1, Jane Doe number 2, and Jane Doe 5 that federal charges be filed against Epstein. We urge the Attorney General and our United States Attorney to consider the fundamental import of the vigorous enforcement of our federal laws. We urge you to move forward with the traditional indictments and criminal prosecution commensurate with the crimes Mr. Epstein has committed. And we further urge you to take steps necessary to protect our children from this very dangerous sexual predator. On 7 July 2008, the line prosecutor corresponded with Epstein's counsel seeking his signed agreement concerning a notification letter to the victims before beginning the distribution of some of the civil compensation provisions of his NPA. The notification did not provide the full terms of the NPA. On 10 July 2008, Epstein's counsel continued to protest victim notification as evidenced by an email to the line prosecutor stating, quote, "We respectfully request a reasonable opportunity to review and comment on a draft of the modified notification letter you intend to mail before you send it." On 10 August 2008, Jane Doe 1 and Jane Doe 2 filed a motion seeking release of the NPA. On 14 August 2008, the line prosecutor emailed Epstein's counsel stating that the court has ordered us to make the agreement available to the plaintiffs. On 18 August 2008, Lefkowitz wrote the line prosecutor that Epstein objected to disclosure of the terms of the NPA, but that Epstein would cooperate with the government to reach an agreement as to the substance of the notification to be sent to the government's list of individuals. Based on the agreement, the information contained in the notification should be limited to: 1, the language provided in the agreement dealing with civil restitution, paragraphs 7 and 10, and 2, the contact information of the selected attorney representative. We object to the inclusion of additional information about the investigation of Mr. Epstein, the terms of the agreement, other than paragraphs 7 to 10, and the identity of other identified individuals. On 21 August 2008, the government sent a letter to Epstein's counsel stating that copies of the victim notifications will continue to be provided to counsel for Mr. Epstein, end quote. Jane 2, number 2, was not informed of the contents of the NPA until 28 August 2008, when the line prosecutors provided a copy to Redacted. On September 2nd, 2008, the line prosecutor sent an email to Epstein's counsel stating, I will start sending out the victim notifications today. In accordance with your request, I've changed the language regarding the victim's right to receive a copy of the agreement. On September 2nd and 3rd, 2008, the office sent Jane Doe 1 and other identified victims amended notification letter stating, quote, the United States has agreed to defer federal prosecution in favor of this state plea and sentence, end quote. On September 16, 2008, attorney Redacted, who represented several Epstein victims, wrote to the line prosecutor to object to the restitution procedures established in the NPA after learning that another attorney established through the NPA would be making unsolicited contacts to the victims. Mr. Redacted explained that the notification letters were misleading because they refer generally to a waiver of, quote, any other claims for damages, quote, without informing them that this waiver might include a valuable punitive damage claim against an alleged billionaire. On September 17, 2008, the line prosecutor sent an email to state attorney Redacted, Kirchner, explaining that the NPA contained confidentiality provisions that required us to inform Mr. Epstein's counsel before making any disclosure. Around this same time period, Jane Doe 1 and Jane Doe 2 filed actions in Palm Beach County seeking money damages from Epstein from sexually abusing them. Eventually, they received monetary settlements of their lawsuits. In moving for monetary judgment, the petitioners make the following arguments in support of their contention the government violated their CVRA rights. The government violated petitioners' rights and confirmed under the CVRA 1. When the government was negotiating and signing the NPA, when the government sent letters telling petitioners to be patient while the government completed its investigation, and 3, when the government did not tell the victims that the state plea would extinguish the federal case. Petitioners also claimed the government violated the rights to be treated with fairness under the CVRA by concealing the negotiations of the NPA. Additionally, petitioners contend the government violated their rights to reasonable and accurate notice when it concealed that the NPA and the federal investigation were implicated in the state court proceeding. In moving for and responding to summary judgment, the government contends that there is no right to notice or conferral about an NPA. It was reasonable for the government to send letters to victims while continuing to investigate the case because the government could not assume that Epstein would plead guilty, and the line prosecutor contacted petitioner's attorney about the state court plea hearing. The government also claims it did not violate the right to reasonable, accurate, and timely notice because the CVRA did not create any right of notice to state court proceedings, and in any event, the government gave notice. The government asserts it did not treat the victims unfairly and used its best efforts to comply with the CVRA, including complying with the Attorney General's guidelines for victim assistance. Furthermore, the document argues the petitioners are equitably stopped from challenging the NPA because they relied upon the NPA in their state court civil actions against Epstein. Lastly, the government contends that petitioners are judicially estopped from challenging the validity of the MPA because they have asserted mutually inconsistent positions, namely that the MPA is invalid in federal court but was binding on Epstein in state court. 2. Summary judgment standard. The court may grant summary judgment, quote, if the movement shows that there is no genuine dispute as to any material fact and the movement is entitled to judgment as a matter of law, end quote. The stringent burden of establishing the absence of a genuine issue of material fact lies with the moving party. Celotox Corp. versus Cotretti, 47 U.S. 317-323, 1986. The court should not grant summary judgment unless it is clear that a trial is unnecessary. Anderson versus Liberty Lobby, Inc., 477 U.S. 242, 255, 980, 1986. And any doubts in this regard should be resolved against the moving party. Atticus versus S.H. Kress and Company, 398 U.S. 147, 157, 1970. The movement bears the initial responsibility of informing the district court of the basis for the motion and identifying those portions of the record which it believes demonstrate the absence of genuine issue material fact. Celotox Corp. 477 U.S. at 323. To discharge this burden, the movement must point out to the court that there is an absence of evidence to support the non-moving party's case. After the movement has met its burden under Rule 56, the burden of production shifts and the non-moving party must do more than simply show that there is some metaphysical doubt as to the material facts. Matsushita Electronics Industrial Company versus Zenith Radio Corp. 475 U.S. 574 386 1986. A party asserting that a fact cannot be or is genuinely disputed must support the assertion by citing to particular parts and materials in the record or showing that materials cited do not establish the absence or presence of a genuine dispute or that an adverse party cannot produce admissible evidence to support the fact. Essentially, so long as the non-moving party has an ample opportunity to conduct discovery, it must come forward with affirmative evidence to support its claim. Anderson, U.S. at 257. Quote, a mere scintilla of evidence supporting the opposing party's position will not suffice. There must be enough of a showing that the jury could reasonably find for that party. Walker v. Darby. If the evidence advanced by the non-moving party is merely colorable or is not significantly probative, then summary judgment may be granted. 3. Discussion. The CVRA was designed to protect victims' rights and ensure their involvement in the criminal justice process. The CVRA was enacted to make crime victims full participants in the criminal justice system. The statute enumerated the following 10 rights. The right to be reasonably protected from the accused. 2. The right to reasonable, accurate, and timely notice of any public court proceedings or any parole proceeding according to the crime or of any release or escape of the accused. Number 3. The right not to be excluded from any such public court proceeding unless the court, after receiving clear and convincing evidence, determines that testimony by the victim would be materially altered if the victim heard other testimony at that proceeding. 4. The right to be reasonably heard in any public proceeding in the district court involving the release, plea, sentencing, or any parole proceeding. 5. The reasonable right to confer with the attorney for the government in the case. 6. The right to fully and timely restitution as provided in the law. 7. The right to proceedings free from unreasonable delay. 8. The right to be treated with fairness and with respect for the victim's dignity and privacy. 9, the right to be informed in a timely manner of any plea bargain or deferred prosecution agreement. 10, the right to be informed of the rights under this section and the services described in Section 5013C of the Victims' Right and Restitution Act of 1990, 42 U.S.C. 10607C, and provided contact information for the Office of the Victims' Rights Ombudsman of the Department of Justice, 18 U.S.C. 3771, parenthesis A, and parenthesis. This court previously held the following with respect to the Crime Victims' Rights Act. First, the rights under the Crime Victims' Rights Act attach before the government brings formal charges against a defendant. Does v. United States 181S 8. Second, the Crime Victims' Rights Act authorizes the rescission of reopening of a prosecutorial agreement, including a non-prosecution agreement, reached in violation of a prosecutor's conferral obligations under the statute. Doe v. United States. Third, Section 3771, parenthesis D, Section 5 of the CVRA authorizes the setting aside of pre-charge prosecutorial agreements, despite the fact that the particular statutory enforcement provision expressly refers to the reopening of a plea or sentence. Fourth, the reasonable right to confer in the case extends to the pre-charge stage of criminal investigations and proceedings. Fifth, the federal sex offense crimes involving minors allegedly committed by Epstein renders these petitioners crime victims under the CVRA. Sixth, questions pertaining to the equitable defense are properly left for a resolution after development of a full evidentiary record. Here it is undisputed that the government entered into an NPA with Epstein without conferring with petitioners during its negotiating and signing. Instead, the government sent letters to the victims requesting their patience with the investigation even after the government entered into the NPA. At a bare minimum, the CVRA requires the government to inform petitioners that it intended to enter into an agreement not to prosecute Epstein. Although the binding effect of the NPA was contingent upon Epstein pleading guilty to state charges, that contingency was out of control of the government. The government's hands were permanently tied if Epstein fulfilled his obligations under the NPA. Thus, petitioners and the other victims should have been notified of the government's intentions to take that course of action before it bound itself under the NPA. Had the petitioners been informed about the government's intention to forego federal prosecution of Epstein in deference to him pleading guilty to state charges, petitioners could have conferred with the attorney for the government and provided input. And thank you, Eliza. And back to you.
Hey, everybody. It's Katie Phang here from Katie Phang News. As many of you know, I had the privilege of being able to be at the Trump Epstein reading room before it was open to the public. I was able to be there to look at these volumes, to spend time with David Garrett and the other incredible people who wanted to bring the reading room to you, the American public. I also had the privilege of being able to spend time with the very first Epstein victim survivor, Danny Bensky, to come to that reading room where we are having this filibuster take place today. And so it was equally as important for me to be able to spend this time with you as we do this 24-hour filibuster reading the Epstein files. I invite you to continue to listen at this time. I'm going to be sharing with you some pages, an excerpt from the government of the the Virgin Islands. They brought a lawsuit against the estate of Jeffrey Epstein, as well as the 1953 trust, which just 2 days before Epstein's alleged suicide, he actually revisited his last will and testament and transferred all of his property into this trust. And so it's not only the estate, but the trust that were sued. This lawsuit was ultimately settled for $105 million plus half of the proceeds from the sale of Epstein's Little St. James Island. And there was also $80 million in improperly obtained economic development benefits that were clawed back from the estate of Jeffrey Epstein to be able to go into a fund to help victims and survivors of Jeffrey Epstein. But I want you to listen carefully to what I'm about to read to you from this lawsuit, because it clearly sets forth some of the schemes, the fraud, and the frankly criminal activity that was being perpetrated by Jeffrey Epstein and others in his orbit to help facilitate his sex trafficking ring. It begins with the beginning of the page that we're kind of like mid-paragraph from the paragraph before, from the page before, and it says, construction at Great St. James after 2016 to continue the scheme to carry out and conceal his trafficking and sexual abuse of young women and children in the Virgin Islands. These actions are also indicative of the Epstein enterprise's disregard for Virgin Islands law. The Epstein enterprise used the Virgin Islands' land, resources, people, and laws for its illicit purposes. Rather than participating lawfully in this community, the Epstein enterprise took advantage of the secluded nature of the islands in furtherance of its crimes. I'm just going to briefly interrupt and say that this is also very similar to what we know about Epstein's Zoar Ranch, that 10,000-acre ranch in Santa Fe, New Mexico, in terms of its kind of secluded nature, its isolation. Moving on. As a result of its deplorable and unlawful conduct, the Epstein enterprise has subjected the Virgin Islands to public portrayals as a hiding place for human trafficking and sex crimes. Subsection C. The Epstein enterprise fraudulently concealed its conduct. The Epstein enterprise fraudulently concealed its actions to prevent detection by the government of the Virgin Islands. This is paragraph 74. The secluded properties at Little St. James and Great St. James were repeatedly used by the Epstein enterprise as the locations for unlawfully soliciting, transporting, transferring, harboring, receiving, providing, isolating, patronizing, maintaining, deceiving, coercing, and sexually abusing young women and children, and concealing these crimes. The Epstein enterprise was able to hide the trafficking ring from law enforcement, despite the fact that Epstein was a registered sex offender. Given the isolation of the Little St. James and Great St. James and the nature of the crimes and of the victims targeted by the Epstein enterprise, the activities of the Epstein enterprise were not readily detectable. Moreover, Epstein's great wealth and power likely made witnesses reluctant to report their observations to the local law enforcement. This is now paragraph 76. Upon information and belief, the Epstein enterprise prevented its employees from cooperating with law enforcement. Employees and others were required to sign confidentiality agreements that prohibited them from speaking to or sharing information with law enforcement. If they were contacted by law enforcement, they were to notify the Epstein enterprise and be represented by Epstein's counsel. Paragraph 77. The employees were directed not to communicate or interact with guests visiting Little St. James and were also directed not to disclose to anyone events that occurred on the island. Monitoring a sex offender with his own private islands and the resources to fly victims in and out on private planes and helicopters presented unique challenges and allowed the Epstein enterprise to limit scrutiny by the government of the Virgin Islands. I'm going to interject here as well. That does also sound familiar. That same MO that we hear right now was one that we were hearing when it came to Zorro Ranch as well, with the private airstrip and the ability to fly in and out without FAA observation. Paragraph 79. Sexual Offender Registration and Community Protection Act requires sex offenders to register in their resident jurisdictions and to make periodic in-person appearances to verify and update their registration information. Paragraph 80. Epstein renewed his registration each year in the Virgin Islands. In addition, beyond this statutory requirement, the Virgin Islands periodically visited or attempted to visit Little St. James to conduct additional address verifications. Paragraph 81. At his last verification in July 2018, Epstein refused to permit Virgin Islands Department of Justice investigators, assisted by United States Marshals, to enter Little St. James beyond its dock, claiming that the dock was his, quote, front door, end quote. Instead, Epstein arranged to be met at his office on St. Thomas. Paragraph 82. Epstein also misled the government regarding his travel plans. On March 19, 2019, the Virgin Islands was notified that Epstein would be traveling to France for 10 days on the private plane owned by Plan D LLC. His notification form did not disclose travel to any other countries. It was later found by law enforcement authorities that Epstein also traveled to Vienna and Monaco during that trip. Paragraph 83. Similarly, the Epstein enterprise sought to prevent DPNR from conducting routine site visits to inspect unpermitted and potentially damaging construction activity on Great St. James. The Epstein enterprise repeatedly objected to DPNR's inspections, referring to them as, quote, invasions, end quote, of Epstein's constitutional right to privacy in his home, which he described and defined as the entire island. These DPNR inspections are required for all construction, and Virgin Islands residents are required to cooperate with the inspections to assure compliance with the law throughout the construction phases. Paragraph 84. These efforts represent Epstein Enterprises' intent to conceal its unlawful activity on Little St. James and Great St. James. 85. The Epstein enterprise also created numerous corporations and limited liability companies in the Virgin Islands to help conceal its unlawful activity. Most of these companies were created in 2011 and 2012, soon after Epstein registered as a sex offender in the Virgin Islands. Paragraph 86. Epstein's pilot, Larry Vysotsky, is identified as a member or co-member in companies that serviced and maintained the planes that the Epstein enterprise used to traffic young women and children. Freedom Air Petroleum, LLC, registered November 28, 2011 to hold assets, and JEGE, LLC, registered October 19, 2012 to hold assets. Paragraph 87. Other Epstein entities include LSJ Employees LLC, registered October 27, 2011, to provide services. Southern Financial LLC, registered February 25, 2013, to provide services. And LSJ Emergency LLC, registered December 2, 2015, to provide services. Paragraph 88. Some of these companies held considerable assets. Financial Informations, Inc., incorporated November 18, 2011, also known as Southern Trust Company, Inc., had assets of approximately $391 million in 2015. And Financial Trust Company, Inc., incorporated November 6, 1998, had assets of $212 million when it publicly filed its last balance sheet in 2012. Paragraph 89. Although often absent in the original incorporation or registration documents or annual filings, Epstein ultimately appeared as president, director, manager, or sole member of each of these companies. Upon information and belief, the purpose of this complex array of corporate entities, some of which may still be discovered, was to allow Epstein to shelter his assets in order to fund, carry out, and conceal his identity and pattern of criminal conduct. Paragraph 90. The estate continues to engage in a course of conduct aimed at concealing the criminal activities of the Epstein enterprise. Please note, if I may, that this lawsuit was filed back in 2015. 2020 was an amended complaint on this lawsuit. And so this is present tense language in the lawsuit back then, back in 2020. On November 24th, 2019, Epstein's estate filed an expedited motion for establishment of a voluntary claims resolution program in the Superior Court of the Virgin Islands. According to the motion, the proposed program was to be designed to establish an independent and voluntary claims resolution program for purposes of resolving sexual abuse claims against Jeffrey E. Epstein. Motion, at 1.